On the record in the matter of the people of the state of Michigan versus Jeffrey Kaysen, file number 24-00683. Counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Mike Mataloni on behalf of the case. He is being brought upstairs right now.
Is he in custody?
He's in the juvenile.
I
just talked to him downstairs and they were on the process of bringing him upstairs. We were just, I was asking. What's that?
How old is he?
17. Yeah.
I don't know if they're bringing him up. They won't bring anybody up. Unless we clear courtroom or clear hallway. So I don't know if they're actually bringing him up right now. Okay. We'll see. I'll call him when he gets up here.
On that file, it's my understanding that Mr. Mataloni will be asking for an adjournment anyways. So I don't know if he's willing to waive his presence, then that could be something that we could handle without bringing Mr. Kaysen upstairs.
I have a sentencing in front of Judge Buchanan at 9:30, and I'm supposed to be in front of Judge Mauer out in County on a case that was previously scheduled. So I'm asking the court if we could move it to June 6th.
We cannot move to June 6th, but are you waiving your client's presence for this purpose?
Yes, I talked to him downstairs. He said he was fine with moving it.
We've already, oh, there he goes.
That's his brother.
Oh, okay, he's not in custody. That's his brother, he said?
That's my
He's in
client's
custody
brother. Yeah.
though. Okay, you can waive his,
He waived his 21-day rule, Judge, on
I
March
see that.
21st.
Yep, okay. And so you have a conflict on today.
This morning, yes.
So we'll reset this. It'll be July 12th. July 12th is the next date. We have a physical at 9:30.
Yes, ma'am, that's fine.
Okay, we'll continue to July 12th at 9:30. We're all set. Thank you.
It was good.
I'm not sure where it was. So if he's in the juvenile detention, your office is like in real estate.
Oh, yeah.
I have zero idea. Where I am going to move it. But yeah, that's maybe the county still runs it. He's not.
Yeah, I know.
I don't know. Well, it's a juvenile detention in the county, so
I know.
because we met with the person who runs it. So she might, I'm assuming. They have to transfer.
I'll talk to Andrew and see,
They have to be
but as of right now,
The younger guys, the other younger guys.
Yeah, if they want to do that,
They were
that's
on
what
the
we'd like
roster.
to do.
Yeah, he spoke to him, I assume. Mr. Mataloni, you spoke to your client downstairs today?
Yep.
Yeah, so someone brought him over.
They had on like a olive green jumpsuit.
I spoke with his juvenile officer yesterday, and I know that they had made special arrangements to keep him out of sight and sound and everything, so.
Got it. We just was wondering who transported him, but I said somebody from Nio Pendes transported him.
So obviously, I'll have,
Yeah, they were asking that question, but I said it must be from the juvenile.
yeah.
On the record in the matter, the people of the state of Michigan versus Dismissal of Delle Bell, file number 24-01243, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing today on behalf of Ms. Bell. She's standing present to my right.
Okay, Ms. Bell, today was the date and the time that was set for a preliminary examination. You had a probable cause conference last week. And we didn't see you. We didn't get any information from your client that you weren't supposed to, from your attorney that you weren't supposed to be here.
Can I address that, Your Honor?
Yes.
I had received an email regarding the probable cause conference. I'd responded to that email informing Ms. Petrowski that we had nothing to be placed on the record and the matter would just be continued on for the exam. When I was here personally last week for the probable cause conference, I believe I also confirmed that to her orally as well. And the way I understood the email was that was a way of conducting the probable cause conference off
Absolutely
the
is,
record.
but we didn't get that. I don't believe. Did you just respond to her personally?
It appears, I looked back at the email and it appears that did happen.
That probably was what the miscommunication was, because
And-
she probably was running in 21 different directions. And if you had told us, we would have just put continue to examine here.
I understand that, and for the future, I guess I will make a point to do that, and I just assumed that was still fine because no one had mentioned to me last week, whereas
Were you
Ms.
here
Bell,
last week?
yes, I was here in person on other matters.
Okay.
And no one had inquired of me, whereas Ms. Bell, or what are we doing with that matter? It's also my understanding, because I spoke with Ms. Petrosky this morning, we were both under the belief and understanding that the matter was still set for the preliminary examination. My understanding is that the people's witness was still subpoenaed. They had not been released from that subpoena.
Oh, yep, that was not adequately communicated to myself or my staff, so they notified me the person failed to appear. I issued a bench warrant. Quashed the warrant, but Ms. Petrosky does send the emails, and she does CC my staff and me for that reason, so that you can reply all, and then we know. That way it'll alleviate some of the miscommunication if possible. Are we continuing to examine today?
I think that would be a decision for you, the judge. My witness was subpoenaed. She is not present today. However, I
May I address that, Joe?
Yes.
And as I'd stated, both the people and myself were under the understanding that this matter was still on the docket for a preliminary examination. And as Ms. Petrosky just stated, the witness was subpoenaed. She was not released from that subpoena. She has failed to appear, and given that, Your Honor, I would ask the court to consider a dismissal without prejudice.
A motion to dismiss without prejudice is granted. Other people do have the right to reissue the charge against you, okay? We'll get your number. Any additional matters for today's records?
that's for the people.
I have nothing additional on behalf of Ms. Bell, Your Honor. Thank you.
Thank you. You can have a seat. We'll get you a copy of the dismissal. Mr. Feigelson, you're here with Cedric Hennessy.
Yes, Your Honor, I am.
On the record in the matter of the people of the state of Michigan versus Cedric Hennessy, file number 23-01840. Counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Yes, Your Honor, good morning. Assistant Public Defender Stephen Feigelson on behalf of Cedric Hennessy, who's standing to my right this morning.
Okay. Today was the date that was scheduled to continue to preliminary examination. Are we proceeding today?
Your Honor, the necessary victim has failed to appear and the people are unable to proceed to preliminary examination. So we'd be moving to dismiss without prejudice.
No objection, Your Honor.
Motion to dismiss without prejudice is granted. Other people do have the right to reissue the charge against you. Do you understand that?
Yes, ma'am.
Okay. We'll get you a copy of your dismissal and any additional matters for the record today.
Nothing from the people.
Nothing, Your Honor.
You're all set. Has anybody seen Mr. Meltz today?
Nope.
How's it going, Mr. Meltz?
Good.
Wonderful.
How are you, Your Honor?
I'm doing well. Do you have Archie White with you?
I have not seen him yet.
Okay. Not seen Archie White, and then Johnson is in custody.
Yes.
You know who's running that?
Yeah, I'm gonna get the page first.
Yes, ma'am. Yeah.
Johnson,
Ms. Robinson, do you have Caswell with you?
I'm sorry?
Do you have Caswell with
I
you?
do have Caswell, but apparently he was released from custody, so I doubt he's gonna be here today.
Oh, no. That's not good.
John Hastings from the student.
Okay. Dependent no longer in council. Well, it's your bench warrant, but if he appears, I'll hold it to the end of the day, see if he appears.
Yeah.
Thanks.
Unofficially, Your Honor, regarding Mr. Johnson, I think it's gonna be us pricing a dismissal on the one, but then we're gonna deal with the PA 53 or the tether violation.
Okay, can we bring up Desan Johnson? Let's see.
And yeah, you know, the officers are.
And you've not seen White, so I'll make sure White. I mean, he's supposed to be almost an hour ago, so. Not gonna pop up. Okay. Mr. Austin left, but I don't know if he wanted to run Garner.
I believe Gardner is gonna be a plea.
Okay. I haven't seen Mr. Etheridge, bench warrant White. We're gonna have Desan Johnson brought up from custody. And I've not seen Mr. Goodrich.
He's bouncing around here.
Yeah.
Your Honor, I've got a sentencing from Judge Flores. If I can sneak in there, if Mr. Johnson comes up, that's where I'll be. I can come back here, obviously.
Sounds good.
Thank you, Your Honor.
I need Robinson on Tower and Wyndham.
I just saw her. She's in the hallway, so I'll grab her 1 second. It's at the very end. Yeah, the jury room. Yep.
I think.
Oh,
Intern.
yes, yeah, that's Cass. She's a Pam intern, and this is Sukaya. And she's also a Pam intern. And then we've got some other interns who are either law students or undergrads who are not here right now. And I'm just gonna dip like 2 seconds in the hallway just to do one last check for victims.
Okay, for the interns, we're bringing someone up from custody, so sometimes we do put them there, just so you know, okay?
Fine with you that we stay here because we.
I don't have a problem, I just want to let you know for your comfort.
It got really full and I was like, I don't want to take up the space.
No worries.
And you just missed it. The brains are on custody.
I got it.
Well, I would tell her. Yeah, so just heads up, you're good to still stay there, but.
They may or may not sit them there, depending on where we are with the docket. Let me get copies for them. Someone bring it up Johnson. Someone bring up Johnson. Who do we have here? Ms. Robinson, who do you have?
This is Mr. Wyndham.
Okay, on the record in the matter of the people of the state of Michigan versus Tavion Wyndham, file number 23-01352. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people. Erin Robinson, Assistant Public Defender for Mr. Wyndham.
Okay, Mr. Wyndham has a exam set for CCW. There was an offer, but he was considering his waiver maybe further. Is that what was going on?
Correct.
Okay, how does he want to proceed at this time?
He's willing to unconditionally waive his preliminary exam today.
That's correct, Mr. Wyndham.
Yes.
Okay, so last week I advised you of your right to have a preliminary examination and the purpose of the preliminary examination. So you have the right to require the prosecution put forth evidence that will establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that, right?
Yes, ma'am.
Want to unconditionally waive it today? Anybody threatening you to waive your exam? Any promises being extended to you in exchange for a waiver? Can you approach? Yes, please. Thank you. Find over date is going to be June 5th. That's the date that the circuit court will get the file from this court. You do not have a court appearance in circuit court on that date, okay? Unless for some reason your attorney wants you rearranged at circuit court, and then she'll file a motion for that purpose, okay? Your next court date will then be a pre-trial. Your attorney will be made aware of that. I have an address for you on Truxton. Is that so accurate?
Yes, ma'am.
And then your phone number ending in 7645.
7546.
7546. No worries, and I don't know that that's what you had, or sometimes we write so fast we mix it up. Area code 480 though,
Yeah.
Okay. So I'll note that here. Any changes to your contact information or address, you should make sure the court is made aware of immediately, so you don't miss any next court dates or communication from the court. Bond. You had an interim bond that was set, that will continue. Any additional matters for today's record?
Nothing from the people.
No, Your Honor, thank you.
Thank you, you're all set. We have, Ms. Robinson, your other matter, Tower present. Yes. Okay.
Yeah. No. Oh, with Tower. Oh,
The record, in the matter of the people of the state of Michigan versus Chavez Monique Tower, file number is 24-01140, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people. Aaron Robinson, Assistant Public Defender from this tower.
Today's the date and the time that was scheduled for a preliminary examination. How are we proceeding?
The necessary witnesses failed to appear, people are unable to proceed, so we'd be moving to dismiss without prejudice.
Assuming there's no objections.
There is no objection.
So the case will be dismissed without prejudice. That means that they have the right to reissue the charge against you within the statutory time frame. Okay? Do you have any questions about today's proceeding? Okay, we'll get you a copy of your dismissal in just a moment. Any additional matters for the record, counsel?
Nothing from the people. No, Your Honor, thank you.
You have Garner with you?
I do, Your Honor. He's out in the hall. We're going to be doing a plea. I'm just waiting to see if Ms. Petrowski is going to, we're going to have a plea form for that.
Oh, we are.
And once we get that done, we should be all set to go on the record with that.
Sounds good. Your response, Yolanda. Yolanda. I see the email from Susan. Tomorrow, my docket, I'm gonna just have exams and then that's all I have, so. If she wanted to do onboarding tomorrow, that would be perfect tomorrow.
Tomorrow.
What do you want to do?
Attorney's right there, so. I saw Mr. Milks, I guess he stepped back out. Oh, there it goes.
Oh, thank you. That's, I was looking for something.
On the record in the matters of the people of the state of Michigan versus Desan Alex Johnson, file numbers 24-00707 and 708. Council appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Yeah, good morning, Your Honor. Stephen Mills on behalf of the council is present and standing to my right at this time.
How are you, Mr. Johnson? You're a little tired, me too, actually. Today's the date and the time set for preliminary examination, and then there's a contempt of court P53 on one file. How we proceed?
As far as the P53, the contempt, I have witness John Hayes from JSG. He'll be appearing via Zoom. And so I have him as a witness for that. I had some additional officers who were also subpoenaed, but last that we checked, they were not present. And then for the preliminary examination, the victims have not appeared.
This is on file number 708, or you have no victims on either?
The other file is a pre-trial. And that one is
Oh, yeah, we received.
by
a
Mr.
global-
Lee and
It's gonna be a
Mr.
global resolution on it.
Yes.
Okay, sounds good. So no witnesses here on the exam. On the bond violation, there is supposed to be JSG. This was scheduled for 9 o'clock. It's 9:31. No one's in my waiting room.
Said that he
Are you okay, sir? You can have a seat.
I've been in communication with him all morning, so I think he just might have either logged off or not logged on, but he yeah, is able to. I just, that's where I'm at, Judge. My apologies.
Oh, wait, yeah, I think this is him. John just popped into my breakout room.
All right, beautiful, okay.
Mr. Pfeiffer?
Yes, Your Honor.
What matter are you on?
I'm here for the Trent Hart sentencing.
Oh, okay, we were waiting for Mr. Etheridge, that was right. Okay. Mr. Hayes is present, so we're ready to proceed on the violation alleging that he tampered with the tether.
That's correct.
The defense would be moving for dismissal just regarding the preliminary examination today, Your Honor. We're moving for dismissal on that one. I'm having a slight technology issue, which is not the court's problem or the prosecutor's problem, but I will need to 1 minute or 2 minutes to confer with my client, Your Honor.
You're having a tech,
I know that sounds very bizarre,
what's the
but
issue?
my computer died in the middle of sentencing.
Oh, so I'm sorry to hear that.
Yes, me too. But
So
I
you need a
believe,
moment to talk to your client?
if that's okay, Your Honor, then we will be ready to proceed.
Are you gonna just do it on, where do you want us to put him?
If I could do it over there,
Okay, we can have him put over there,
thank you, Your Honor, I appreciate it.
off the record. On the record in the matter of the people of the state of Michigan versus Trent Hart, file number 24-00627, counsel appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Morning, Your Honor. Attorney Derek Etchell, also public defender on behalf of Mr. Hart, who is in the courtroom standing to my right.
How are you, Mr. Hart?
How are you?
I want you. Today is the date that was set for sentencing. I do have a pre-sentence report and recommendation. It was dated prepared on May 17, 2024. Counsel, did you get a copy of it?
Yes, Your Honor.
Is there a reason for us to make changes, corrections, or updates on here?
Your Honor, I reviewed it with Mr. Hart, and he advised me there are no additions, deletions, corrections.
Your Honor, there is a matter that we need to discuss that came to my attention, and I mean, within the last 30 minutes. And to make sure that there is a clear record, we received.
Can you give me a moment, please?
Absolutely.
Okay, you can proceed.
Thank you, Your Honor. We received a victim impact statement from the victim in this matter. Effectively, it's a recantation saying that nothing happened, so she doesn't want him getting punished. And I did not know about that until this morning. I looked and I did not see that it went out to defense counsel. Mr. Etheridge, is that correct?
We did not receive it from your office, but we did receive it as part of the PSI.
Okay. Now there were text messages attached. Did you receive those as well?
I don't believe so.
Okay. Those definitely need to be sent to defense. I'm happy to do that right now, or if we need to adjourn, we can do that as well. I'd still ask sentencing go forward per the plea, but just in terms of due diligence, I want to make sure defense has all of that. For whatever reason, it didn't flag anything in our system to let me know that this existed when it came into our office. That's why I found out about it looking at it just now.
Just for my clarification, you said that you received a letter with text messages attached from the victim recanting, saying nothing happened?
Yes, Your Honor.
How do you want to proceed?
Your Honor, I haven't received the text messages. I don't know if the court has. I would
I
like
don't even
to-
know if I have. Is this?
We have the victim impact statement where she is recanting. We did know that at the time of plea, there's a couple of paragraphs in the police report, but it wasn't a detailed statement as it is now in this victim impact statement. At the time of the preliminary exam, Mr. Pfeiffer intended to go victimless at that time. And there are also third-party witnesses that were part of this and observed this that, as far as I know, haven't recanted their statements about what happened.
Yeah.
The understanding, if it went to trial, Mr. Pfeiffer would call experts to try to explain the recantation. Based on all that information at the time, the information we had at the time, Mr. Hart decided to go forward with a plea resolution and pled no contest, in part because some of the recantation. So we call it possible civil liability.
Okay, so you want an opportunity to see the text messages before you sentence? I'm not following what you want to do.
Yeah, if the court don't have them to consider, and we're not considering them, let me ask Mr. Hart.
I just emailed them to you, Mr. Etheridge. And that's just because I did not want to appear in any way that people were keeping anything from defense before he was sentenced. That's that's why I'm just trying to make a clear record as possible from this.
Your Honor, I've had the opportunity to speak with Mr. Hart regarding the text messages. He's advised me that this time he does not necessarily want to see him to go forward with sentencing. The court don't have them and it's not taking them into consideration. And just for the record, he and I have talked about possibly withdrawing his plea. He's advised me he doesn't want to withdraw his plea. He wants to go forward with sentencing.
Okay, and from my information, he's currently on probation.
Yes, Your Honor, he's on probation in Eaton County. I believe, based on the report and what he's told me, he would be off of probation there August 13th of this year.
Okay, and then you submitted a petition for sentencing under 769.48, which he's not eligible.
Yes, Your Honor. At the time of submitting that and at the time of the plea, he advised me and another attorney that was here on the family's behalf that he did not have any misdemeanor convictions or assaultive convictions. So there was a killer brew if eligible, he could get IDA, but now we're seeing that he does have a conviction that we weren't aware of. And he doesn't deny it. Talking to him this morning doesn't deny that conviction.
Okay, so that was the basis of the communication as to if he intended or wanted to make a motion to withdraw his plea. Based on that, because I recognize it was, I mean, you can't really kill a root to granting, but there was no objection to 769.48. And if he was eligible, he's not eligible.
Yes, Your Honor.
With that, he still wants to move forward with it.
I've discussed the matter with Mr. Hart regarding the court's reading of the Killer Brew agreement and his ability to withdraw based on not getting the 76948 status. He's advised me that he wishes to go forward with sentencing, not withdraw his plea. We also discussed the victim's statement, the recantation, and whether or not that changes his position of withdrawing his plea, and he advised me it doesn't. He wants to go forward.
Okay, you can make our conclusion.
Thank you, Your Honor. Your Honor, in regards to the PSI and him not providing additional information regarding the facts of this case, that was based on my advice to him because he pled no contest, the reasons he pled no contest. So I would ask the court to hold that against me, not him. Your Honor, this is a very respectable young man. He's taken responsibility, even with all the stuff we talked about today with the court. He is much different now than he was years ago, even at the beginning probably of this case. He takes care of his son. He has joint custody of him, of the child week to week. He's around 10 years old. Takes care of him, takes him to after schooling. He works a full-time job. He is currently recommended that he serve 10 months probation. I would ask the court maybe to consider a lesser term of probation because this is a case where if he is successful and doing well, he can't get off early. So I would ask the court maybe to up front consider that and consider the information and the recantation and everything that's going on here and give him a lesser term of probation. And if he's not successful, the judge could always extend his probation. This is going to go on his record, unfortunately, instead of having the 694A, and he understands that. And even with the opportunity to withdraw his plea, he's advised me he still wants to go forward. He would ask the court to consider what he's doing on Eaton County probation. He's already doing drops, and he has already done and completed a lot of counseling and testing and rehab there. He would like to hopefully not have services duplicated if the court's going to have him doing drops, et cetera, that he's already doing in Eaton County, at least for the next 3 months, it looks like. He's advised me that he's been clean for 3 years and has had no violations on his probation there for at least the last 3 years. Again, he's scheduled to get off probation there August 13th. He's already doing random testing. He's already had counseling, rehab. He is required to pay, as the report says, $6,000 restitution, which he's working toward. So he does have a significant amount he has to pay there. So he'd ask the court to consider waiving any fines, fees, or costs the court can. Even though he does have a job and a full-time job making around $16 an hour, he still unfortunately qualifies for public assistance and has a limited income after taking care of his living situation as well as his child and paying child support and taking care of his kid. I have no doubt that he would be successful on your probation and be able to complete your probation. He's completed probations in the past. I know in the past he's also had probations that have been revoked, but he does have the capability, and I think he's in a different position than his right now, that where he can complete his probation. He's completed YTA probation in Clinton County, I understand, in the past. It doesn't have in the report where he's completed, but only where he's not completed. He does have that capability, and I believe that he's about to complete the Eaton County probation that he's been on since 2020. Your Honor, I would ask the court to take all that in consideration and leave any conditions of probation up to the court. Thank you.
Oh, did your client want to make a statement at all?
I just wanted to say I take full responsibility for what I did and some of the actions in my past life. I'm glad today is come so I can move on. Finally about to move on from Eaton County. This was a hiccup, but I believe I'm going to complete this too if you allow me to be on probation and move on from this as well. Thank you.
And you're supposed to get off probation, you said in August?
August 13th.
Were you violated because of this incident?
They did pick me up for it, and they saw that I haven't had any violations. They haven't saw me in years since.
You didn't have an official probation violation.
I think my concern is looking at your past criminal history, how many times you've been on probation in such a short period of time. And then, of course, as Rich mentions that no one talks about your success on probation. Well, that's because there's been more unsuccessful attempts at probation than successful. And I see where your probation was revoked in 2020. It says that your probation was terminated here on 3 separate cases. So that by itself wouldn't lend the court the understanding that you would be a good candidate for probation, but obviously you're on probation now. Hopefully you'll be successfully discharged. And then about 25 going to 26, how old are you? 25. You're very young. So that means you were doing probation when you were about 19, 20?
Yeah.
could explain why there were so many unsuccessful attempts. Because you were young, being a knucklehead. And hopefully you've grown from that. You have a child, you have responsibilities to yourself and to your children or child. And hopefully you are not just showing the court or willing to show the court that you can be successful on probation, but that you can be successful in not putting yourself in positions that put you on probation. I don't think you want to keep coming back to court for things, do you? I would hope not. I would hope you want to move forward and have a meaningful life that doesn't involve this kind of court interaction. I'm going to adopt the recommendation with modification. I agree with Mr. Etheridge, which is that this type of a conviction on probation does not grant you the opportunity for early discharge if successful. So I will not do 10 months. I'll do 5 months probation. While on probation, we have the following conditions. Continue the no contact order. Make it peaceful contact only.
Your Honor, just for the record and for the defendant's education, there does still appear to be a no contact order in place through a PPO with the 30th Circuit Court. So I just don't want him thinking that this means he can start talking to her again without any consequence, because that PPO is still in place.
Correct. This doesn't address any personal protective order or any order from another court. This just addresses my order, which there was a no contact order in this file. And I was assuming actually that this was the mother of your child. Is that inaccurate? Okay, that is not the mother of your child? Okay, so very few reasons why you need to have communication with that person moving forward, correct? So you no contact order. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to possess a firearm, ammunition, or weapon of any kind while on probation. You're not to use or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You understand that? Yeah. You're required to submit to random preliminary breath testing and or urinalysis testing. You're responsible for the cost of that. You're currently on probation in Eaton County. I don't see a reason why you need to drop twice. And so if you're ordered to drop before our court on my probation, but you are dropping at the same time in the other court, I will allow you to provide that information to satisfy your dropping here while you're on both probations. That way you're not incurring two expenses for dropping, and you're not dropping twice for the same time period, okay? You're not to be in any bars or any nightclubs while you're on probation. Let's see, how far did you go in school, sir?
11, 12. I apologize. I ended up getting my GED.
Okay, you did complete your GED. You are employed. Going to order that you maintain your employment and provide evidence of that to probation. You are going to participate in an anger management group. Do you have any questions so far? Any questions?
Your Honor, does this being on my record stop me from getting a house?
I can't speak to how this affects your ability to buy a home in the future, sir. Okay, I don't see why it would, but I think they really want to know if you have the credit to purchase a home. That's what they're concerned about. Or if you have the cash, I don't think they're gonna say, you know, I can pull his criminal history. I'm not gonna take his cash to buy this house that he's going to own because he has a prior criminal history. So I don't know why anyone would be pulling your criminal history to buy a house, but maybe a bank might, I don't know. Okay. Nonetheless, do you have any questions about probation though? No. Okay. $30 per month oversight fee you're responsible for while on probation. There's a $75 crime victim rights fee that you're also responsible for. You have a soundtrack going on in the background. Okay, he pled guilty to count 3, or no contest to count 3. Or waive discretionary fines and costs. Fines and costs of $275. And you can make monthly payments on that, okay? There's an advice of rights as to probation. It states that you've been placed on a term of probation before the 54A District Court. The terms and conditions have been individually tailored and are specific to address your assessed risks and needs, except for cases of domestic violence, criminal sex crime, stalking offenses, or offenses where defense of guilty but mentally ill were asserted, you may be eligible for early discharge from probation. Again, you pled no contest to a count of domestic violence, so you would not be eligible for early discharge from probation. Do you have any questions about that? Okay, you'll check in with our probation department before you leave. Make sure that they have accurate contact information for you. And then hopefully you won't have, if all goes well, I won't see you. At least not here. If I see you, that means something's not going well. And we don't want that. Because if something doesn't go well, then you'll have to do 93 days in jail, okay? And we don't want that. We want you to not be here for anything that's not positive, except for when it's time to discharge you successfully. And then hopefully the next time we hear from you, it's because you'll be telling us that you bought your house. Any additional matters for the record?
Not from the people, Your Honor.
No, Your Honor, thank you.
Good luck to you, sir.
Thank you, Your Honor.
Your Honor.
She might, okay. Mr. Mills.
Yes, sir.
Back on the record in the matter of Desan Johnson. Mr. Mills, you need to discuss something with your client. How do you want to proceed?
Thank you, Your Honor. I appreciate the court giving us a little bit of time here, Your Honor. Your Honor, regarding the bond violation in this matter, regarding the cut tether, my understanding, I'm speaking to my client, further and updating him regarding the what's going on today. If I understand, he would like to enter a plea regarding cutting his tether at this point for that bond violation.
Is that correct, Mr. Johnson? Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Thank you, sir. You can put your hand down. Okay, so I do have a bond violation alleging that you tampered with your GPS tether, which was ordered as part of your pretrial conditional release from custody. And I believe you advise you of your right to have a contested hearing on that. You understand your right to that hearing? Understand that you're facing a contempt of court if found to be in violation of your bond conditions. Side-eyed Mr. Milks, like, you understand that? Okay, so contempt of court is punishable with 93 days in jail and or up to $500, sorry, $7,500 in fines. You understand that? And you want to waive your hearing and you want to enter a guilty plea as to the allegation that you tampered with your GPS tether.
Yes, ma'am.
Anybody threatening you to get you to waive your hearing and plead guilty? Okay. As to the violation that you tampered with your tether, how do you plead? On a factual basis, please.
Thank you. Mr. Johnson, I'm just gonna ask you a few questions, okay? You understand that as part of your bond conditions, you're required to wear a tether, is that correct? Yes. And did there come a point when you did in fact tamper with and or cut off the tether? And you knew that that was in violation of your bond conditions, correct? Okay, thank you, Your Honor, that was suffice.
Any questions from the prosecution?
Not the factual basis, no.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. There's no witnesses here on the underlying offense.
That's correct, Judge.
Okay, you made a motion to dismiss. Your motion to dismiss is granted without prejudice. That means the people have the right to reissue the charge against you within the statutory time frame. Okay? Credit time served on the bond violation.
Your Honor, if I may,
Yes.
Mr. Hayes informed me that he was wondering if restitution could be ordered as a part of the sentencing on the bond violation for the tether that was function destroyed. It was a $630.
$630 in restitution to JSG is ordered. Any additional matters for the record?
No, Your Honor.
Not in this matter, Your Honor, thank you.
We all set on that one, and we'll set his assault and battery for a state misdemeanor day. No, the restitution is on the PA 53. Yeah, but contempt of court has nothing to do with the. Yeah, I don't know what they're gonna do back there. They have to figure, they're gonna get some new codes or something because. Gotta. June 25th. At what time? 10. Let's see. Your bond. And that is 1,000 cash surety. Are you addressing bond today?
Yes, Your Honor, I'm sorry, June 25th
At 10 a.m.
10 a.m. Thank you, Your Honor.
That's, I think Mr. Lee is on that one.
That's correct.
We gotta pay the restitution, sir. Sorry? I recognize that. That wasn't my question. I didn't say, where are you now? We gonna pay the restitution. And so you're only being held on these matters, or you have other matters? Okay, you have a bond of 1,000 cash surety, a readdressing bond.
If I may, Your Honor, currently, one of the problems with my computer being down, which I was trying to figure out with my clients, how long he's been in at this point. I know the court gave credit for time served, but I am asking if the court would consider a PR bond, understanding that we just got off a bond violation here, Your Honor. However, I do have some concerns just regarding my client's mental health and some stability issues. I will say that he does have people from his brothers here, as well as friends, people from the community who want to ensure that my client's making good life decisions here. Obviously, that hasn't always been the case, but with the restitution being owed, I advise my client, this is something that's going to happen, most likely was the restitution. He'd have to start making payments on that. And so I think if he can get out, show the court some good faith, that he can make payments towards that restitution, get a job, I think go a long way, not only in negotiating process possibly, or whatever happens with the misdemeanor case, it could give him a leg up, whatever happens with that. So the fact that he has served time at this point, I'd ask that the court would consider or extend the grace, Your Honor, to a PR bond to give him that opportunity to begin at least paying down that restitution. He is a man of little means at this point, but every little bit towards restitution helps pay his debt in that sense.
What's his address?
That's the other issue, Your Honor. He's going to have to provide the court with an address where he was living, and I believe the previous address the court had was from a friend who was recently moved. So he would have to provide the court with an updated address at this point.
He's got family here to make sure he's making the right decisions. They don't know where he's gonna stay.
When I was speaking with my client, Your Honor, that's the best that I can offer the court this time.
What's your name, sir? Can you stand up so we can hear you? What's your name? You're his brother? Okay. Is he supposed to be staying with you?
No, that's the only thing I got.
So he can't stay with you?
It was
Okay. Okay, so we don't know where Mr. Johnson can stay. Mr. Johnson, do you have a phone number? You have a phone number?
Yes, ma'am.
What's your phone number?
708-890-937.
Need to provide a valid address to the court as to where you're gonna be staying within 48 hours in order to avoid another bond violation. Yes, sir. I can't hear you.
The halfway house is a possible idea for like an adult shelter.
Yeah, if that's what they'll let them stay there, we just need the address.
And I'll talk to you. Thank you, Your Honor.
Just a moment. Is he engaged with community mental health?
I think it's been a little while, Your Honor, since his last engagement with community mental health.
You need to report to community mental health. You need to report to community mental health so that you can re-engage in their services. And you need to do that by next week, okay?
Yes, ma'am.
Just for clarification, Your Honor, that includes making sure he's on medications that he's supposed to be on, and taking those as prescribed. And
Correct. You need to comply with all your medication requirements. And your brother's gonna make sure you do that, correct? Okay? Do you have any questions? You're not to engage in any assaultive or threatening behavior. Understand that.
Yes, ma'am.
You need to return to court when you're supposed to. When's your next court date, sir?
10 o'clock.
Of what month?
Next month.
Next month, correct. June 25th. You're going to return to court. You follow up with Mr. Lee. If you have any questions, he's your attorney on that matter. And then your brother's gonna make sure you remember your court date, isn't he?
Say it again, please. June 28th.
25th,
June 25th.
10 a.m.
Do you have any questions? Bond is admitted to 1,000 personal recognizance. There's still a no contact order in place for the protection of the alleged victims. You have to be wherever they live, work, or go to school. I don't know that you know where they live personally. I don't know that you know them personally, but at least you may allegedly know where they live, where they work. You're not to be there, okay? Do you have any questions? Any additional matters for the record, counsel?
Nothing from the defense. Thank you, Your Honor.
You're all set, sir. You said this for show cause on June 25th, the restitution. This, I'm sure we're gonna have to figure out what his payment plan is.
Yeah, you're good to go. Thank you so much.
Mr. Austin, you have Isaiah Ashe?
Mr. Ash, yes,
Mr.
Your Honor.
Ash, okay, sorry.
He's out in the hall. I'm still waiting on a plea form for that, but I'm ready on Mr. Garner.
Okay, on the record in the matter of the people of the state of Michigan versus Vincent Garner. File number 24-01391, council appearance.
Assistant Prosecutor Peter Petrosky on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing today on behalf of Mr. Garner. He is standing present to my right.
Okay, Mr. Garner, today's the date that we set for a preliminary examination on assault with a deadly or dangerous weapon in a domestic violence. It was a plea, I believe, that was going forward today.
Yes, Your Honor, I have the necessary paperwork for that, if I may approach.
Right. Okay, so the people are offering for the defendant to plead no low condere or no contest to amended count 2 of aggravated domestic assault under MCL 750.81A2 with no objection to 769.48. If eligible, people will dismiss count 1. There's a killer rule of no upfront jail. That's complete and accurate understanding of the plea offer.
Yes, Your Honor.
It's my understanding as well, and that's what I've conveyed to Mr. Garner.
Mr. Garner, you want to accept that offer? What's the purpose of the no contest plea?
Your Honor, the potential for civil liability.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, put your hand down. You understand your rights, sir, as it relates to the charges that's been brought against you? Okay, you have an advice of rights and plea information sheet. There's 2 pages. This is the signature page. Did you sign this? Okay, you read this document? You understand all the rights listed here? Do you have any questions about these rights? Speak a little louder.
No, ma'am.
You have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any witness that the prosecution calls to testify against you. You have the right to remain silent, not have silence be used against you at your trial, but you can waive silence and testify on your own behalf if you like, or you can subpoena witnesses to testify on your behalf. You also have the right to present evidence that you believe show a defense to the charge being brought against you. You understand that those are all rights you would be giving up today by entering a no contest plea. Anybody promising you anything to make you give those rights up? Has anybody threatened you to get you to want to give up those rights and enter a plea today? Are you currently on probation or on parole? You understand that if convicted of this, this could be a conviction that you may need to report to your current employer, or you may need to put this on a future job application. It also could have impact on travel or immigration status you may be seeking. So you may want to go visit Canada one weekend and you be denied entry. You understand that? As to the amended charge of aggravated domestic violence, how do you plead? Police report from Lansing Police Department, case number 245-190-4289, alleging date and time of May 8, 2024, at approximately 6:20 hours at the area of 5917 South Waverly Road, Apartment A, City of Lansing, Ingham County, State of Michigan. That the accused, identified as Vincent Garner, and the alleged victim, Jamisha McCarthy, had been in an on and off dating relationship for approximately 3 years to 4 months. The officers made contact with McCarthy and Jamisha at that dispatch address. She advised that she was sleeping in her bed when she heard a loud banging at the front door. As she came downstairs, opened the front door, and observed the screen door was already open and Vincent was standing in front of her. Vincent advised Jamisha that he told her that she would see him again. Vincent then grabbed Jamisha's shirt with his left arm just under her throat. Jamisha at first showed to me that Vincent had a knife in front of him at his chest level and pointed it at her while he was holding her and with his left hand by the shirt. The additional factual basis.
Nothing for the people.
Satisfied, Your Honor.
The court is satisfied with the factual basis. I find the reason for a no contest plea to be appropriate. The plea is accepted and an entry of conviction of guilty will be entered by way of no contest plea. Matter is set for sentencing July 25th at 9 o'clock in the morning. When you leave here, you need to go down 1 floor to the probation department so you can check in, and they'll get you scheduled for a pre-sentence interview so they can provide me with a report and a recommendation as to how you are to be sentenced. They'll also advise as to whether or not you're eligible for sentencing under 769.4A, okay? Do you have any questions for the court at this time?
And attorney gets one.
This is the one for our file, so for this one for our file. We'll get you down to probation. Any additional matters for the record?
Nothing for the people.
I have nothing additional, Your Honor. Thank you.
Thank you. Thank you. I'm not seeing Mr. Goodrich.
I've seen him here this morning, but I haven't seen him recently.
Yeah.
And what are we doing with Mr. Ash?
That's going to be a misdemeanor plea, Your Honor.
Okay, you still working through that paperwork?
Yeah.
Member Carr, what are we doing with that?
It's a plea to a disorderly, Your Honor. No, upfront jail.
Okay, are you ready on that one?
I am the prosecutor.
I'm still plea sheet on that one.
Okay, on the record in the matter of the people of the state of Michigan versus Amber Carr, file number 24-00218. We don't need a plea sheet on it disorderly.
Okay, thank you. Assistant Prosecutor Paige Petrosky on behalf of the people.
Morning, Your Honor. Attorney Derek Hitch, also posed defender on behalf of Ms. Carr, and Courtroom standing to my right.
How are you, Ms. Carr? I'm blessed. I'm well, thank you. Okay, so this matter was scheduled for preliminary examination and the people are moving to amend count 2 to disorderly.
That's correct. And we would be dismissing count in the habitual offender notice as well.
If I could approach with the vice of right, Your Honor.
Thank you. You want to accept that offer, ma'am? Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Okay, I have an advice of rights of the information sheet. It's 2 pages these days. You read this document. Yes. You understand the rights listed here? Yes. And you want to give up all of these rights? Yes, ma'am. And that's your signature? Yes, ma'am. Okay, so you understand that you have a presumption of innocence, correct? Yes, ma'am. You want to give up your presumption of innocence? Yes, ma'am. You have the right to proceed to trial. You have the right to a jury trial. You understand that? Yes. You have the right to see, hear, or question any other witnesses the prosecution intends to call against you at trial. You have the right to call your own witnesses at trial or present evidence that you believe show a defense to the charges being brought against you. You have the right to silence at trial and not have silence be used to prove or imply that you're guilty, or you can waive your silence and testify on your own behalf. You're going to give up those rights as well. You have the right to require the prosecution prove each element of the charges beyond a reasonable doubt at your jury trial. You want to give up that as well so that you can plead guilty to disorderly conduct. Okay. Is it disorderly jostling?
Yes, Your Honor.
I threaten you to plead guilty to disorderly jostling. Has there been any promises made to you in exchange for a guilty plea today? Are you currently on probation?
Yes, well, yeah,
Bond, right?
fine.
Okay, I do see that you had a pending matter in Jackson County. Okay, I understand that.
This
Guilty.
occurred before she was on bond, Your Honor, so I don't think it would be a bond violation.
Okay, I understand that a guilty plea could result in the conviction that you may need to report to your current or future employer. And you also understand that a guilty plea could have impact on where you can travel or get immigration status. You might want to go to Cancun. They say we don't take people with disorderly jostlings. I don't know. It could happen though.
What?
Yeah, it could happen.
I ain't gonna be
Canada
going to
definitely will stop you. I don't know about Cancun.
I see no pictures, I'll be all right.
Okay, but you understand that that's a potential impact. Do you have a victim here on this today?
We do not, Your Honor.
Yes, you do.
Oh, we do? Oh, he is here. Okay. Hi, I'm in the hallway, so my apologies. We do have him here.
Okay, very good. Okay, as to the disorderly jostling, how do you plead? Factual basis, please.
Thank you, Your Honor. This trial will draw your attention to September 29th of 23. Were you at 1202 Furley Street?
Yes.
And that's in the city of Lansing, Ingham County, state of Michigan, correct? And you had contact with the James Edward Davis, correct?
Yes, sir.
It's my understanding he's the landlord of an apartment you were staying in, correct?
Yes.
And at some point that day, you and him had a disagreement over trash being placed in a dumpster, correct?
Yes.
And he confronted you about that issue, correct?
Yes.
And during this confrontation, you and he got into a jostling situation where you guys pushed each other, correct?
Yes.
That's sufficient, Your Honor.
Just, I might have missed this. Did that incident take place in the city of Lansing?
Yes.
Ingham County?
Yeah.
Oh, in
Yeah.
okay, then venue is appropriate. I have no further questions.
We're satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Any objection to immediate sentencing?
Nothing, or no objection.
No, Your Honor.
I am waiting for them to bring me her criminal history. And then I don't know if your victim wants to make an impact statement today.
I'm not seeing either, so I will ask him.
No problem. The record. Counsel, you can make allocution.
Your Honor, this time we would ask the court to consider fines and costs only. I know this car does have some criminal history, but it's primarily substance abuse type stuff like drunk driving. She is currently on bond. Currently on bond in Jackson County. That includes Graham. And she's also doing drop stairs part of her bond conditions. That case is still pending. Likely will result in some type of resolution where she would be on probation there. She takes responsibility for the action she did that day. I know there may be a disagreement on what occurred, but based on other witnesses' testimony or video stuff that we received, it appeared that this would be the appropriate resolution. So we'd ask the court to consider fines and costs only. If the court is going to give any term of probation, I would just ask the court to consider non-reporting probation with her complying with her bond conditions in Jackson County. Thank you, Your Honor.
The victim can give their statement.
Thank you.
My name is James Davis, James Edward Davis. You need me to spell it?
It's common spelling?
Yes.
Okay.
Okay. We had an altercation. She says that we both pushed each other. I did not touch her. She pulled a dog stake out of the ground and actually tried to stab me with it.
A dog stake?
A dog stake, yes.
What's that?
The kind of stake that you push in the ground to keep your dog tied.
Oh, okay.
She took that out of the ground and tried to stab me with it. And she's always lied and feels empowered because she's gotten away with stuff. And, you know, act like she's owned stuff that she's not owning up to responsibilities, and has always gotten away with stuff, lying and cheating and stuff, and really getting away with stuff and being empowered to feel like she can get away with stuff and never being held responsible for what she's done. And it's almost like the system empowers her to get away with stuff. Oh, I can do this, I can do this, and I can do this, and nothing happens to her really. I just get a lick on the hand. I get this and I get that, but I'll be back out.
How do you know those things?
Because I hear her talk.
Oh.
I've listened to her tell me, I'm gonna take all your stuff. This is my property. And I tell her, you're not even my tenant. She was my tenant's girlfriend that stayed in my duplex and did this and did that. And all kinds of stuff happened at my apartment in shambles and did all this. And I was just glad to see him gone. But then when this happened, I'm like, really? You're gonna try to stab me with the dog stake? I'm much bigger than her. So all I did was just call the police. And 3 or 4 months, I don't know, that was back in September. And I was wondering what was going on with it. Then I talked to the prosecutor and they called me. So she said, are you gonna show up? I said, oh yes, I'm gonna be there because I wanna see that she gets what she has coming to her. because she's getting away with so much that it doesn't make any sense. And so I would like to see, I'm all about, everybody needs a second chance. I was in trouble myself when I was 24. Anyways, you all need a second chance, but then at certain times we got to be responsible and held accountable for what we do. And go from there.
Thank you. Okay, and did your client want to make a statement at all?
Yes, Your Honor.
So I had a third party witness, and the only thing I could say is that I was defending myself in self-defense when I picked up.
That's not what you just pled guilty to.
Your Honor, it's an affirmative defense that she is giving up the right to
Right.
claim based
I don't want
on,
to hear about it.
based on the fact that she is pleading to what actually occurred.
She gave up a lot of rights to do that, so
That's
she
fine.
can't now use that to.
It's just,
Well,
a-
I do
sentence.
I'll say, he don't know me, he don't know my prior history. And to speak on me and say I've been smacked on the hand, I've done recovery court 2 times successfully. Yes, I've fought with addiction, and it's something not to play with. So to sit there and say that I've never been punished for the things that I've done, he don't know me. He just knew me in my addiction, and that's not who I am outside of my addiction. So for him to sit there and say that, that's not right.
Thank you. I asked them, how do you do those things?
Right.
I your criminal history here, it's 12 pages long.
Correct.
It's extensive.
And everything that I've done in my criminal history has always been because of my addiction.
That's pervasive
Right.
throughout your criminal history, is that it's clear that you have a underlying issue with substances, because the more than 50% of your convictions are relative to the use of a substance or some level of substance abuse. And so I recognize that you've done some kind of treatment courts before, and maybe experienced some level of success.
And this last time I relapsed was because I lost my sister. So that's mainly why.
I was gonna say, you must have experienced some success, but then had some relapse. And you're currently pending another case relative to substance now?
Yeah.
Okay, in another court.
That's why I asked them to put me on scram and do drops. That way I did not use everyone.
Where is that case? right now?
Jackson County.
No, I mean, in the process, do you have a trial coming?
A pre-trial is coming up.
Circuit court.
Yes, circuit court. That's in August 2nd.
Okay.
So it could be probation, it could be 5 years probation, it could be recovery court, it could be prison. You know,
Yeah,
so
this is the third offense, OWI?
yeah,
Yeah,
so you know,
and I've seen more than 3 OWIs
so
on
to
your.
say I've been
on your
slapped on the
record.
wrist, I've never been slapped on the wrist.
Well, I'm not here to talk about your OWI really as it relates to what your sentencings were, but this is definitely, it's not just you, you do have some convictions here relative to the same actions. It's not just you doing or taking those actions that harm you. Your record reflects that when you are under the influence, you're putting other people at risk. And that's something that you need to be self-reflective of. You need to not only not put yourself at risk, but how dare you put other people at risk when you are engaging in self-harm or actions that violate your body and your system. As it relates to this, it started off as a felony, two counts. There was an habitual offender notice there. And I recognize that you've made a decision to give up what you believe to be an affirmative defense and to enter a guilty plea, or no contest plea, I should say. No, you enter a guilty plea. You enter a guilty plea. So you really voluntarily and intelligently gave up your rights to assert your affirmative defense. And to enter a factual basis that you engaged in conduct that was disorderly, and that conduct involved some jostling, which does require some level of physical activity. So that you gave up that the right to assert that you did that for your own protection, or because someone was going to harm you, or you believe that you were going to be harmed. And then I have your criminal history, which is extensive. I think that you have some issues that need to be addressed, and that doesn't go without notice for the court. And so it would be inappropriate for me to not address that. I don't typically put people on probation for disorderly. I do sometimes, but it's not often. That's why I asked to see the criminal history report. You and I are the same age. But chose very different paths. I don't know anything about your upbringing or how you got to where you are. But you can't just assume that because he's your attorney or that she's a prosecutor, that doesn't mean they didn't have any trials or tribulations that could have caused them to resort to this type of behavior. You can't assume that because I wear a black robe that I didn't have anything in my background that didn't have what you may believe reason to cause me to engage in this kind of behavior. What you can't believe is that we chose to make other decisions. You drive the vehicle as it relates to the choices that you make. And so you have to decide, I'm no longer going to engage in this kind of behavior. I no longer want to continue to cycle in and out of court or be on probation, where now you're facing prison time because of my actions and because of decisions that I'm making that are damaging and detrimental to me, but to others. You have to make that decision. And so because of that, I am going to refer you to probation. I'm going to have you placed on a term of 6 months probation before this court. While on probation, you will undergo a substance abuse assessment. And if you've had one recently, that should be provided to probation for consideration. You'll follow all recommendations for treatment. You employed, ma'am? Why are you not employed?
I have 2 rods in my pelvis right now, and I'm getting a fight taken out from my hand. I can't lift my 20 pounds, and I can't stand longer than like 45 minutes right now.
So you're on disability of some sort, or?
Not yet. I'm filing for it.
While on probation, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess any alcohol or drugs or any other substance unless you have a valid prescription. You're on a scram tether already, correct? What county was this, Jackson?
Jackson.
And this is part of your bond?
Yes.
I'm not gonna order her to PBT at this time because she's on scram. Continue the no contact order. You're not to have any contact directly or indirectly with the victim in this matter, James Davis, okay?
Yes, ma'am.
you have any questions about your probation?
Yeah, how is it work? Is it, I'm gonna have to.
You're gonna go down, you're gonna go downstairs when you leave here, check in with our probation department, and you report via Zoom if you have the ability to do that, otherwise you'll have to report in person, okay?
Okay. Oh, wait, that's a lot of gas.
It's a $30 per month oversight fee that you're responsible for while on probation. It's $180. $75 crime victim rights fee, which will be assessed, plus a $50 state minimum cost, which will be assessed. I'll waive discretionary fines and costs at this time. Total fines and costs is $305, and you can make monthly payments on that, okay?
Okay.
Any additional matters for today's record?
Nothing from the school.
Oh, yeah, thank you.
Thank you. We'll get you down. Thank you. We'll get you down to probation. All right.
If you are me right.
You have Mr. Ash.
Yes, we're ready to proceed, Your Honor.
On the record in the matter of the people of the state of Michigan versus Isaiah Ash, file number 24-01377. Mental appearance.
Assistant Prosecutor Paige Petrowski on behalf of people.
And thank you, Your Honor, and good morning. Jared Austin appearing today on behalf of Mr. Ash. He's standing present to my right.
Okay, Mr. Ash, today was the date set, date and time set for a preliminary examination of police officer assault, resist, obstructing in a retail fraud, second degree, and there's going to be an offer or plea today.
That's correct, Your Honor. Our offer for Mr. Ash is for him to plead guilty to an amended count 1 of attempted police officer assaulting, resisting, obstructing, and plead guilty as charged to count 2, retail fraud, second degree, with no objection to HIDA.
1 second, do we have an interpreter here on that matter? Sorry. What's the issue with the interpreter? You know what the issue with the interpreter?
The attorney just stepped out.
Where's the, can the interpreter come in here, please? She's up there.
Some issue with the dialect or something?
I have no idea. Okay, we have to go on the record. Okay. Wonderful. Okay. There was an offer.
There was, I already stated.
Thank you. Okay, offer is for the defendant to plead guilty to amended count 1, attempted police officer assaulting, resisting, obstructing, and plead guilty to count 2, which is retail fraud in the second degree. There's no objection to sentencing under HIDA. Complete and accurate?
Yes, and so sorry, I think I forgot to give the PAC code for the attempt, so I can do that, because unless I surprised myself and wrote it, but
Okay.
I have the PAC code right here.
Okay.
It is 750.81 D1 parentheses, A, parentheses.
Perfect. And your client wants to accept that offer.
He's indicated to me that he does.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Okay, you can put your hand down. Okay. I have an advice of rights and plea information sheet here. This is your signature. You read this document. You understand all the rights here. Do you have any questions about these rights? And are you willing to give up all of those rights today so that you can accept the offer?
Yes, ma'am.
You have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt at a jury's trial by proving each element of the charge being brought against you beyond a reasonable doubt. You understand those rights? You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any witness the prosecutor calls to testify against you. You can waive your right to silence and testify on your own behalf at your trial. You can subpoena witnesses to testify for you at trial. You can present evidence at trial that you believe show a defense to the charge being brought against you. You want to give up all those rights?
Yes, ma'am.
Anyone threatening you to do that?
No, Your Honor.
Any promises being made to get you to give up rights today? Are you currently on probation or on parole?
No.
Understand that a guilty plea can result in a conviction that you may need to report to your current employer or put this conviction on a future job application. Type of conviction could prevent you from being able to travel to certain states or countries, and not states, countries, or also have impact on where you can get immigration status. As to the amended count 1 of attempting police officer assaulting, resisting, obstructing, how do you plead?
Guilty.
And as to count 2 of a retail fraud 2nd degree, how do you plead?
Guilty.
Factual basis.
Yes, sir. Thank you. Mr. Ash, taking you back earlier this month on May the 5th, were you at the location of 6200 South Pennsylvania Avenue in Lansing, Michigan?
Yes.
And is that here in Ingham County?
Yes.
And is that the Meyer store?
That's good.
And as you were leaving that store, did you come into contact with an officer from the Lansing Police Department?
Yes.
And was that officer in uniform that you recognized him to be a police officer?
Yes.
And you understood, based upon your interaction, that he wanted you to stay there as he was investigating some type of shoplifting or retail fraud incident, is that correct?
Yes. Yeah.
Okay. And is it true that you failed to obey what he told you to do? And you did that by walking away and eventually starting to run away to a car in a parking lot, is that correct?
Yes, I did.
And that was after he told you to stay there, he wanted to investigate a matter, is that correct?
Yeah.
And I'm sure you don't know or remember the name of the officer, but if the complaint in the police report indicated that the name of that officer was Jonathan Chau, C-H-A-U, do you have any reason to disbelieve that?
Don't know the name. Say it's incorrect.
Okay. And while you were at that location in Meyer, is it true that you took property or merchandise from Meyer without paying for it?
Never left the store.
You had gone past the point of checkout, though, correct? Okay. And when you come into contact with law enforcement, you were at essentially the entry and exit door past the checkouts, is that correct?
Yeah.
And the value of that merchandise would have been over $200, is that correct?
Yeah.
Additional factual basis.
No, Your Honor, thank you.
The court is satisfied with the factual basis. I'll accept your plea if I can be made free voluntarily and intelligently. This matter is set for sentencing July 25th at 9 o'clock in the morning. But when you leave here, you need to go downstairs to probation and check in so they can get you scheduled for a pre-sentence interview. And they will use that interview to author a report about how you should be sentenced, okay?
Yes.
If you have any questions for the court at this time? Any additional matters for the record, counsel?
Nothing from the people.
Nothing additional on behalf of Mr. Ash, Your Honor. Thank you.
Thank you, Mr. Ash. I'm gonna get you down to probation in just a moment. You can have a seat, okay?
Thanks.
on the record in the matter of the people of the state of Michigan versus Nio Pendes, file number 24-00739, counsel.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And good morning, Your Honor. Bruce Davis, appearing with Nio Pendes, who's present and standing to my right. Please state your name. Nio. Last name? Pendes.
Oh, and we had an interpreter here.
Yes.
What's your name, ma'am? Hi, what is your name?
Mahbouba Fida.
Can you spell that?
Mahbuba.
Okay.
And last name Fida.
Okay, thank you. And then there was an issue with the dialect.
Yes. I spoke to my client, spoke to his family. There's a difference in dialect. He can't understand everything that she's saying. From different countries, is that correct?
Yeah, I speak their language, but I'm from Afghanistan. They want somebody from Serbia, because they're Serbians. They want exactly from their own country. That's more comfortable with the translation.
So they need someone from Serbia.
He doesn't understand a lot of what she's saying.
Yeah, so they said they want a dialect from their own country.
Judge, he had a previous civil matter, and an interpreter was used. His family has the contact information for that interpreter. They could provide that.
That would be helpful.
To the clerk, the other information would be, okay.
Okay, so we have to reset this matter.
I do want to address his bond. I filed a motion to his bond conditions.
So the issue is that he was close or less than 200 feet of where the alleged victim lives?
Yes, that's correct. And the way his bond is currently set, he's unable to return home. So he's been staying in a hotel since this case was filed, and then no contact order was imposed. So it's causing a great financial hardship on his family. I believe they spent in excess of $5,000. Is that right? On his hotel expenses. So his family has to cook dinner for him, travel to the hotel, take the dinner to the hotel, have to pay for the hotel, which really causing a hardship on his family. He hasn't been convicted of anything, Judge. So what I'm asking, the court order a standard no contact order. He can return home. He won't have any contact and stay in the house. He won't have any contact with the alleged victim in this case.
When he was arraigned, he advised he was going to stay with his son in Hope.
That hasn't been the arrangement. He's been in the hotel. Judge.
That's what he told him. He was ordered to update the court with any changes. He didn't do that.
He's been in the hotel. I'm not sure. Yeah, Judge, they've been reporting every Wednesday where he's staying, reporting with pretrial services. So he wasn't able to stay with his son. So he's been in the hotel, and it's just causing a great hardship on my client and his family.
What hotels he's been staying at?
So America's Best Inn. America's Best Inn in Lansing.
It was the exclusion zone is actually 2,000 feet, not 200 feet, is what this says. Your client's address is what?
What's the address? 3112 Sunderland Road in Lansing.
Okay, so that is obviously what, a couple of houses are across the street from 3118 Sunderland?
They're neighbors, next door neighbors.
I mean, Your Honor, I understand that the potential for financial hardship that this might pose to Mr. Pendes. However, from my conversations with the victim, she's expressed considerable fear, even with the no contact order in place. This incident, with not getting into the facts of it, but the fact that he was in such close lived in such close proximity, I think was a factor in this case, and it has a significant impact on her ability to just go about her daily life. She's been incredibly impacted by this, and so I just would like the court to take that into consideration when looking at bond.
Is this up for an exam today?
It is.
Is your victim here?
Yes, she is. She's in the Judge Ward's library.
Oh.
And I have officers here as well.
Yeah, this is a CSC 4. The use of force or coercion. I recognize that there's been no conviction, but these are serious allegations. And there's really not much else that the court can do to get around that. When he was arraigned by Judge Buchanan in March, he said that he would reside with his son in Hopes. The court had no reason to believe he was staying in a hotel. And additionally, if he couldn't reside with his son, the court doesn't have to forgo their responsibility, which is the protection of the public and potential victims, to help avoid him accruing any potential cost. I can't allow him with these type of allegations be unsupervised next to this alleged victim.
A standard no contact would accomplish what the goal is for him, for no harm and to protect the victim.
Which lives next door.
Correct.
And she's making an allegation that he used force or coercion to sexually assault her. It's the allegation.
That's the allegation, yes.
Correct.
And he's been compliant.
At the address of where you want me to allow him to just have a no contact order.
Correct.
So they're gonna come and go and see each other, got pending court dates, because my next court date's probably not till July right now, or maybe even August. And there's not gonna be any communication, that the court can't do that. So the motion to deny is denied for that purpose. Any additional issues for today?
If we could just get a date so that way I can provide it to the victim, be a little bit easier for her to know when to expect things.
July 12th.
July 12th.
Is our next court date.
At what time?
8:30.
Thank you.
So the families have a.
All right, it's your idea. So the circuit court sets up the interpreter request. So we need to be able to get that information to them. Yes, please.
Mira, MIRA, Simonaska, SIMUNOSKA.
Oh, okay, we'll forward that information on to them and
I have a phone
they'll
number.
find out if that is someone who is qualified. Phone number?
586-822-1366.
Okay. Okay, so July 12th at 8:30 works for your calendar.
Yes.
Okay, any additional matters for today's record?
Nothing for the people.
Nothing.
Mr. Carter, Are we're running Hodge? Or continuing Hodge?
Yes.
It was ran. That's the three.
Okay. Oh, show cause on more?
Present.
What's the show cause? File.
It's in-
On the record in the matter of the people of the state of Michigan versus Elijah Moore, file number 20-000839. Okay, Mr. Moore, today was the date set for show cause, and I'm assuming it's because you owe some money.
That's correct. I had, I think it was or something like that. I seen the magistrate a while ago. It was for $150. I just haven't been able to get the money.
Are you working?
Yeah.
Where are you working?
I work with Armor Plumbing with like part-time, so I work like 2-3 days out the week with them. And then I have a roofing boss from Adams Roofing. And he fills up the rest of my week.
Okay, so there was originally a large amount of restitution. Is he paid?
I have a receipt actually from a while.
It was 125 for restitution.
I just showed them here.
I'm trying to figure out what you owe the ones. So you just owe 125 is what it looks like, and I'm trying to figure out what it's for.
So restitution has been paid.
Restitution's been paid in full, so what's the fine? It is $75 crime victim rights, $50 state minimum cost that you were supposed to pay. And why were you not able to pay that?
Just been so behind on bills since I've been incarcerated. A lot since a few jobs as well.
I'll waive the balance and close the file. You're all set.
Thank you.
You're
Have a good day.
same to you. Nope.
Someone just stepped out, so maybe it's him.
I was gonna say they probably won't get far.
Yeah.
Sweet. Yeah, man. See. Okay, we can have Mr. Hodge brought up. I don't see anything from the prosecutor. I'm gonna find them.
Motion? The briefing?
I said the clerks. should send it off to the- she sees it.
Well, I think part of the issue is that they, when they get stuff, if they get it, they're just printing it in a file when it's supposed to be a judge's copy sent to the court. It's like, wow, you think I go look for file, go look for files, look for a thing, so they just putting it in there, so this was in there, there was no judge's copy submitted. And then we didn't get yours, if you sent it to the clerk's office, they didn't put it in here. So there's been no judge's copy provided to me, but the attorney provides judge's copy to the court staff.
Your Honor, I did send it to you as well as Ms. Nash and the clerk's office.
They didn't provide me a judge's.
If it's sent to the clerks, that's.
Yeah. That's problem.
So in the future,
No, this is not an issue. for you
okay, I
all.
just was like, wait a second, I
It's
don't
the
know what I
clerk's
did
office.
wrong.
They just
Okay.
stick it in the file. They don't tell us that they received something. They just stick it in the file. I'm not going to the clerk's office, pulling files, looking behind there every
Yeah,
week
yeah.
to see what's in there.
Okay, cool. I just was like, wait a second, I don't know how to do this different, so. Awesome.
They're supposed to print it. And they have a stamp that says judge's copy. The record in the matter of the people of the state of Michigan versus Thomas Hodge, file number 24-00293 FY, comes to appearance.
Prosecutor Paige Petrosky on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Hodge, who is present sitting at council table.
Okay, today was the date and the time that was set to continue examination that was held back on April 4th. And I requested that the attorneys brief the issue of the legality of searching the entire vehicle on the basis of probable cause that there was open intox. I believe was the argument of the prosecutor. The court did not receive those briefs prior to, due to the error of a criminal clerk. They put one brief inside the file, didn't put the other, and didn't bring these briefs to the court's attention. But I did have an opportunity to review your briefs this morning. And you can continue with your argument.
Thank you, Your Honor. I would rely upon the arguments made in my brief. I know that you've very recently just heard them, so I don't want to belabor any points. I would just want to make one clarification. In Mr. Carter's brief, he alleges that I misrepresented the sequence of events in my argument, and it even includes, the question that I asked Officer Rincon, what did you find when you searched the vehicle? Admittedly, hindsight is 2020. I should have elicited clearer testimony when I was asking those questions. But through both of the questioning of the parties and especially the cross-examination by Mr. Carter, the sequence of events was established that when the vehicle's door was opened, that was when Officer Rincon looked down and saw the baggie of cocaine in the car door. That was not entirely clear from my initial questioning. I'm taking notes for the future. However, we did establish, based off of the testimony and clarifying that that was the sequence of events, that they had the probable cause for the open intox. They had developed that probable cause. Defendant was outside of the car when Officer Rincon went to open the car door to conduct the search for probable cause based upon the open intox. That's when he looked down and saw into the vehicle. I know there's a slight discrepancy between the two, the testimonies between the two officers. And the other officer, I would say, although I don't particularly love inconsistencies in testimony, I don't think any lawyer truly does, or any prosecutor, I should say. But the other officer's testimony, even if his statement of the exact sequence of events is the more accurate one of the two, in both circumstances, both of those circumstances, the probable cause was developed as one of the very first, thing that was done when the car was opened to be searched for probable cause for the open intoxicant. And because that probable cause was developed at that point for that contraband in the vehicle, the automobile exception and the search incident to arrest of an automobile exception would also apply. Yes, so that's all I'll say on that point. And just reserve any argument for rebuttal.
Thank you, Mr. Carter.
Thank you, Your Honor. I would disagree. First, I'll handle the quickest one. The search incident to arrest does not come into play in this case at all. So that cannot be used as an exception here. Search incident to arrest is one that you're searching the vehicle because to get evidence for the arrest. If in fact the individual is within the span of the vehicle. My client was handcuffed and put inside a squad car. So you don't have search incident to arrest because my client can't reach into the car. There's not going to be any issue of destroying evidence. What we have in this case is that we have officers that have reasonable suspicion, but not probable cause. These are two different things. Reasonable suspicion is often confused with probable cause. Reasonable suspicion is a step before probable cause. At the point of reasonable suspicion, it appears that a crime may have been committed. The situation escalates to probable cause when it becomes obvious that the crime has most likely been committed. What we have here is that an officer sees cans, not bottles. If he saw bottles and saw yellow stuff and said, oh, that looks like beer, he doesn't, or he could see the level of liquid in there. What he saw was open cans, has no idea that there's any alcohol in them, don't know if they're empty, don't know if they're full. So he has reasonable suspicion here. That does not rise to probable cause at this point. We have an officer who then takes the defendant to the back of the vehicle, outside to the back of the vehicle, and tells him multiple times, I am going to search your vehicle now. This is based on open intox, suspicion of open intox. His very first thing that he does when he searches the vehicle doesn't go to the cans to see if, in fact, his reasonable suspicion now escalates to probable cause. He doesn't do that. Not only that, we're dealing with open intox. So why does he need to flip the whole car based on probable cause of open intox? He's looking under the seat for open intox. I don't think that you can get open, have an open can of beer or alcohol under the seat. It would spill all over the place.
Well, you could, because the way they have our lovely law written, doesn't matter if you screw the bottle back on. If you pop the seal, it's considered open intox.
All right, fair enough. But I think the evidence of the crime is right there inside the counsel, but he doesn't do that. He doesn't look at those cans to determine whether or not his reasonable suspicion has now escalated to probable cause. He starts searching that vehicle right from the get-go. I would disagree with the prosecutor indicating that when he opened the car door, he sees in plain view. That was not the case. I watched the video.
I don't want to hear anything about what you watch. I want to talk about what we testified to.
Well,
and he did say that he saw, when he opened the door, he saw the baggie in plain view. He testified to that.
He opened the door and he said that he one of the things that he saw was a baggie. He had to lift open the baggie, look at it to determine what was in the bag. I just don't think he has probable cause to search this vehicle. I think what he had was reasonable suspicion that did not rise to probable cause. And I don't think that an open intox then allows him to flip the whole car. Not only that, it's a pretext. He sat there behind the car and told my client he was going to search that whole vehicle. I'm going to search the vehicle. I'm going to search the vehicle based on probable cause. I don't believe he had it. I'd ask the court to suppress it. Thank you.
So just a few quick points. Respectfully, Mr. Carter's reading of Gantt is incorrect. Under Gantt, it explicitly states that when they're only authorized to search a vehicle incident to arrest without a warrant when the arrestee is unsecured and within reaching distance of the passenger compartment, as he had mentioned, or based on their totality of the circumstances, it is reasonable to believe that evidence of the crime of arrest may be found in the vehicle. Given that the crime of arrest in this circumstance would be the open intoxicant at this point in the investigation, it is reasonable to believe that there would be evidence of an open container of alcohol in the vehicle, because that is the basis of the entire criminal charge of open intoxicant. That is explicitly stated that it is reasonable to believe evidence relevant to the crime may be found in the vehicle as a situation in which the search of a vehicle incident to arrest would apply. Additionally, this is just brief, but I know that there's been a lot of hay made about the officer not immediately checking the can to see whether or not there was alcohol in it. The officer did testify, and I apologize, I don't remember what the brand was, but the officer did testify that the open cans appeared to be cold, and they were in in the cup holders of the vehicle, the front of the vehicle, and that they were alcohol, or excuse me, that they were cans with a brand name of alcohol on them that he recognized as a brand of alcohol. So for that reason, although he may not have immediately, jiggled the can, he at that point, or he had basically he had established that probable cause, and then additionally, it was his testimony that he saw the baggie in plain view when he initiated the search by opening the door. So we can't ask an officer not to glance down when they open a car door. I think that's unreasonable. It'd be one thing to ask them not to. It makes sense, they can't, there are certain things that they cannot do, but to ask them to close their eyes until they are only looking at the exact thing that gave them the probable cause is unreasonable.
Okay. The court has heard the testimony of the officers back on, again, April 4th, for the purposes of the exam. We did hear Officer Nicholas Rincon. He testified that on the date in question being on or about February 1st, 2024, that he reported to the address of 1121 Keystone Ave, also identified as a laugh queue, and that he reported there for the purposes of a fraudulent complaint or vehicle about allegations of fraudulent activity. He saw a vehicle matching the description that was given to him over dispatch. Stated during his testimony that he spoke with the person in the vehicle, that person he identified in court at that time, being the defendant in this matter, Thomas Hodge. Stated that the defendant was parked in a handicapped vehicle. He testified that there was an open container of alcohol, that he asked the defendant to step out so that he could search the vehicle. To Ms. Petrowski's point, he did give some clarifying testimony. I think it might have been on his cross about, or after his cross during a redirect, about the appearance of the cans, the brand, and that they appeared to be cold. He specifically testified on his direct that there was a conversation between him and Mr. Hodge about those containers when he asked Mr. Hodge to step out the vehicle, that Mr. Hodge had advised him that the cans were old. He obviously didn't believe that. He wanted to search the vehicle. He stated that he performed a pat down of the defendant, or a pat down was performed, and that there was a large sum of money that was located. That when the front door was open to the vehicle to perform the search, that there in plain view was what he's described as a bag that could later was tested and found to contain or tested positive for controlled substance, that being cocaine. And then he also testified that he searched under the seat and found a firearm under the driver's seat in a fanny pack, and 30 grams of meth under the driver's seat, 5 grams of crack in the driver door, that was stored in multiple packages, and then large amounts, he testified, would be an indication to him that it was for the use of distribution. He also testified that there was located a steel wool typically used as a filter for glass pipe to help people smoke. And again, $6,000 in funds he claims was located. And so the issue as it relates to whether or not there was sufficient probable cause to search the vehicle, I would agree with Mr. Carter that the automobile exception, I don't believe it applies here. I don't believe that after he removed the defendant from the vehicle, he can no longer use, or the automobile exception can still be used. However, at least the portion that he's arguing. I do agree that the officers had, based on their observations, that they see cans that identify with alcohol in the car. They obviously have probable cause to arrest, and they obviously can search the vehicle for evidence supporting that crime. I don't know why the officer didn't immediately pick up the cans to see, hey, what's inside these cans. Could be because they stated, or he stated on his testimony that he believed the cans to look cold. But the officer says he opens the car and in plain sight, he locates what he believes to be consistent with a narcotic. It's later tested and found to be a narcotic. Do I think it was reasonable as part of that search for the officers to look under the seat or around the driver compartments area to see if there was any other evidence of open intox? As I stated, even in your argument on the motion to suppress this evidence, there could have been a bottle that could be sealed, because the way the law is written for open intox, once you crack that seal, let's say you were at a friend's house and you had a bottle of liquor with you and you all took shots at the house and then you closed the bottle back up, but you put that bottle under your seat, that would still constitute a violation of open intox, because you can access that while you're driving versus putting it maybe in the trunk of your car, because now the seal is popped. So is it reasonable to believe that the officer would, in seeing these cans, who he's being told are old, but he thinks they're new, search to see if there's open on intox? I believe it is reasonable. I also believe that if he patted him down, incident to him being detained and fines $6,000 or large sums of cash, then now we're opening up areas for new reasonable suspicion. He also testified that he looked under the seat and now he finds a fanny pack with a firearm. But the testimony that he saw in plain view when he opened the door, a baggie of cocaine, I think that gives rise to probable cause to search the entire vehicle. Now, whether or not his testimony about was credible as to whether or not he could see that in plain view, I think that's an issue for the finder of fact for jury, because the court didn't see the video. The court can't tell you whether or not when he opened the door that was what was seen in plain view. I can only rely on his testimony. I think that portions of his testimony I believe could lack credibility, but I don't think that his entire testimony lacked credibility. And I don't think that the credibility issue that I see has anything to do with him intentionally lying, but maybe a lack of experience, or maybe a lack of recollection of how things went down when they went down. I could be completely wrong though. It could be that he intentionally did a pretextual search. But I'll leave that to the finder of fact at the circuit court, or to any further motions at the circuit court to determine whether or not that evidence should be suppressed. Based on the testimony of both Officer Rankin and Officer Nikoff, I think there is sufficient probable cause, and I think that the search was appropriate. And so the bind over will be made on counts 1 and counts 2. Controlled substance delivery manufacturing, count 1 being of methamphetamine, count 2 of cocaine, counts 3 and 4 weapons carrying concealed and firearms by felon will also be bound over to the circuit court. There's counts 5, 6, and 7 felony firearm and habitual offender that will also be bound over based on the testimony evidence of the officers at the time of the exam. Bind over date in this matter will be June 5th. That's the date the circuit court gets the file from the district court. You do not need to appear in circuit court on that date. Do you understand that? So unless your attorney is making a motion for you to be rearranged, at the circuit court. You will have to appear in circuit court until your next court date, which will be a pre-trial. Okay, bond in this matter was set at 15,000, 10%, and that will continue. Any additional matters for today's record?
Nothing for the people.
Nothing for the defense. Thank you, Your Honor.
You're all set.
All set.
That's okay.
Was that all?
We've got one more that's supposed to be a waiver, Tarian Jackson. I've seen Mr. Goodrich on and off, and I was under the impression that Mr. Jackson was present.
I thought Jackson was in custody on a writ.
Yeah,
And I have not seen Mr. Goodrich one time today.
You said in the back for a little bit, but I'm not sure. I'll shoot him an email, see what's up. The transcript.